We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Lorandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Lorandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. Throughout time, children have been victims of adults. We all know that. But in the 1970s, Senator Mondale, who later became Vice President Mondale, learned how to use that fact politically. He created what is called the Mondale Act. What he learned was that if you were for increasing the budget for the Department of Defense, you'd win some votes and you'd lose some votes. If you were for increasing welfare payments, you would win some votes and you would lose some votes. But if you were against child molestation and hard on child molestation, you win votes and you win votes. Out of that political reality came the Mondale Act. The act was very well intentioned and has done a lot of good. But it has also had some extremely adverse effects. The law requires that there be mandated reporters. Doctors, ministers, psychologists, psychiatrists used to have a privilege, and if they received information from you, they would not report it. The law changed, and there was an exception written into the privileges for child abuse and child molestation. A doctor, minister, psychologist, psychiatrist, etc., is now mandated to report it. If they fail to report it, they can be criminally prosecuted. On the other hand, if they do report it, and let's say they were negligent, they do great harm, the fact of the matter is they will be given civil immunity. Civil immunity means that they cannot be sued. With the carrot and the stick being that they will be prosecuted, and the carrot being that they will be protected from civil lawsuits, people report even frivolous cases. After the passage of the Mondale Act, millions and millions of cases were reported. That is what created this hysteria about child molestation allegations and child abuse allegations. The second negative effect that came out of the Mondale Act is that enormous amounts of money were provided for district attorneys to prosecute these cases. Do you know how much was given to the defense to defend against false allegations? Nothing. Not one dime. There was a total imbalance of power because All of the funds went to the DA, special teams of DAs to prosecute, to DA expert witnesses for the prosecution, and on and on. The next thing that occurred was that we got a series of biased, one-sided laws. These have been passed every year since the Mondale Act. Also, in order to prosecute these cases, a whole field of what you would call junk science has been developed. Mental health professionals and medical professionals who have the answers to how you can find out which cases are true and which are false. Most of these theories were not based upon valid research, and this led again to easier prosecutions, but a lack of accurate prosecutions. To overcome this imbalance of power, the one-sided and biased laws, and the junk science that developed around this area, we created our own team. This team specializes in nothing but these types of cases, and by specializing, we're able to level the playing field and even turn it into our client's favor. I have several immediate warnings I want to give you that will protect you from what's to come. The first warning is a concept called the pretext phone call. The pretext phone call is when the police have a child or a relative of the child place a phone call to you. The theory behind it is that the police want to get to you while your guard is down and get you to confess to something. While the phone call is being made, it's normal practice for the police to be sitting there, feeding questions written down on pieces of paper to the individual who placed the phone call. The concept is okay, and it is legal. However, it is misused. Think about getting a phone call from somebody that says, "You abused me. If you say you're sorry, I won't go to the police." Well, that puts enormous pressure on somebody who's innocent to say, "I'm sorry." In that way, it's over, and they don't have the police involved. However, when those words, quote, "I'm sorry," close quote, are later played back to a jury, it's going to sound like, "I'm guilty." What we recommend is that if you get one of these calls, just say no, nothing happened, and hang up. You do not want to spar with the cops that are on the other end of that phone call. Stay away from it and immediately call us. The second warning is that at any time you're going to be subject to a search and seizure. A warrant may be issued and your house searched, your car searched, and your computer searched. If this should happen, do not interfere with the police officers. You do not want charges of obstructing a police officer to complicate this matter. The third warning has to do with talking to the police. Most people believe that if you don't talk to the police will think you're guilty. Well, it doesn't matter what they think. What matters is the evidence. The police have been trained in a process called the Reed method of interrogation. Now, you haven't heard about that before, but let me tell you this. Back in the 1930s and 40s, the police could beat you with a rubber hose to get a confession. The Reed method of interrogation is a psychological rubber hose. You can be beaten with that psychological rubber hose, and I guarantee you that you'll confess to killing your mother, even if she's still alive. It's that powerful. That is why we tell people, do not be interviewed. Do not be subjected to an interrogation. Ask for an attorney. Assert your rights to remain silent. You should do that whether you're guilty or innocent. What comes out of those interrogations can hurt you, even when you're innocent. I want to explain to you what we call the three-ring circus. Sometimes false allegation cases have to be defended in several different areas. That is why we call it the three-ring circus. In addition to defending yourself in criminal court, in some cases, a spouse will begin a divorce case at the same time. Divorces are considered civil and are litigated in the family court. In addition to your criminal defense, the state may file a petition to stop you from having contact with your children. This may be litigated in the juvenile court. Also, if you're a licensed professional, like a physician, a dentist, a nurse, a psychologist, or a therapist, the state may also file against you in the state's licensing administrative court. You can see why we call this the three-ring circus. Sometimes there's even a fourth or even a fifth ring in the circus. And you must remember, in some states, the government may seek to have charges filed against you in a criminal court, the juvenile court, and in licensed administrative courts all at the same time. In our experience, this teaches us that the prosecutor's office will do just about anything to pressure you to settle for a felony prison term. Obviously, few of us have the funds to fight all of these battles at the same time. That is why these tactics by the prosecution are so effective in compelling the defendant to make some kind of plea bargain to end the suffering. We recommend damage control, or what our emergency room colleagues might call triage. This means that you must pick the battle that is most important and put all of your resources into that fight. We believe that this is always the criminal court. Why? Because you cannot visit your children from a prison cell. You cannot enjoy your marriage from a prison cell. You cannot practice your profession from a prison cell. At the same time, we believe that you must use a defense team that is completely aware of what the standards are in the family law court, the juvenile court, and the state's administrative court, and is able to assist you in those courts also. It is important to make sure that whatever is done in any of these other courts does not hurt your criminal case, and vice versa. This is just another reason why we have experts in our group in the area of family law, juvenile law, and state administrative hearings. Shaken baby syndrome, or SBS, is a term used to describe a constellation of injuries and the mechanism of abuse that causes these injuries. The major signs of shaken baby syndrome are subdural or subarachnoid hematomas, which are bleedings in the membranes that cover the brain. Retinal hemorrhages, which are bleedings in the back of the inner surface of the eye, with little or no external injury. In some cases, there are broken bones and fractures of the skull. The broken ribs are said to be caused by the manner in which the child is held around the rib cage during the shaking. When a fractured skull is found, it is usually seen to be caused by the head striking an object during shaking. Brain injury in these cases is usually caused by an individual who shakes an infant, usually under the age of 2, severely back and forth. Infants who are less than 2 do not have the developed neck muscles of older infants, and so the head will whip and lash back and forth. Because these young infants' brains do not yet fill the entire cavity of the skull, the brain becomes bruised as it literally bounces back and forth and rotates inside the skull as the child is shaken. The rapid acceleration and deceleration and rotation of the brain also tears the bridging veins that covers its surface, which accounts for hematomas or bleeding in the brain. The combination of surface bruising and hematomas ultimately leads to cerebral edema or swelling of the brain. Not all infants die from SBS, but if the swelling of the brain cannot be controlled, the brain tissue deteriorates when it runs out of space in which to swell within the skull. It is usually the cerebral edema or brain swelling that leads to death. If the child does not die, brain damage or mental retardation are common as a result of the edema. The original medical research article on shaken baby syndrome was written by Dr. John Caffey and was entitled The Whiplash Shaken Infant Syndrome, Manual Shaking by the Extremities with Whiplash-Induced and interocular bleeding linked with residual permanent brain damage and mental retardation. There are rarely witnesses to abusive shaking. Therefore, the case usually is a matter of attempting to recreate what occurred by using mechanical descriptions and analysis of the injuries. As you can imagine, these cases turn into a battle of the experts. The opinions of these professionals can be contradictory because no one has sufficient scientific data in this area. It is not possible or ethical to create a controlled study that measures the effect of shaking on a real infant's brain. Unfortunately, opinions are sometimes based on personal bias when there is no scientific information available. Child advocacy experts claim that shaken baby syndrome injuries can never be caused by a fall. This is based upon the idea that a short fall cannot create the necessary acceleration-deceleration that bruise and tear brain tissues. But this is not always the case. Studies on artificial brains subjected to falls have shown that acceleration-deceleration forces are 40 times greater when the head is suddenly stopped by an object than when the head is shaken in midair. Government statistical reviews of children who have suffered short-distance falls show skull fractures, subdural hematomas, and subarachnoid hematomas. In addition, autopsies of automobile accident victims have described some of these same injuries. This empirical research demonstrates that it is possible for the brain to be damaged by an accidental fall or sudden accidental impact. That is why when a parent claims that an accident occurred, the defense attorney must place into evidence research data showing that the injuries that the child sustained could have been caused by an accident. One of the serious problems with shaken baby syndrome is that researchers have not actually seen a child being shaken and then done an autopsy to show or measure the injuries. Without scientific studies to guide the cross-examination of child advocacy experts, shaken baby syndrome is open to exaggerated claims about how violent the shaking must be in order to cause the injury in any given case. Descriptions from the child advocacy experts of a child having fallen from the third-story window or having been slammed against the wall while swung by the feet to sustain the injuries have enormous emotional impact on a jury. However, these unsubstantiated and unscientific stories interfere with the jury's fair determination as to whether or not the injury was an accident caused by another caregiver or whether or not the defendant is guilty of manslaughter, second-degree murder, or even first-degree murder. In shaken baby syndrome cases, a mother or a female babysitter is just as likely to be charged with child physical abuse or murder as is a husband or male babysitter. The person that is charged is normally the individual who was caring for the child when the symptoms first became evident. Another claim of the child advocacy experts is that shaken baby syndrome injuries are so severe that the symptoms of such trauma would be immediately apparent, making it impossible for anyone to claim that an injured child appeared normal when it came into his or her care. In other words, there is no time delay between inflicting the trauma and observing its symptoms, say the child advocacy experts. Nothing could be further from the truth. In the cases that our office has handled, prosecution witnesses on cross-examination have attempted to claim that their research supports their theory that there is no time delay between injury and symptoms. When our researchers analyzed the studies that the child advocacy experts named, they did not find any evidence to support the no time delay theory. In fact, the main study that our team found stated that there could be a delay between the time of the injury and the time the symptoms showed up, due to the fact that it takes time for a 2-year-old's brain to swell and fill the cavity space. Yet, a number of child advocacy experts continue to make these unsubstantiated claims, despite the lack of any scientific evidence to support their opinions. Our researchers have found numerous studies that strongly support a delay between injury and symptoms, and not minutes, but many hours in some cases. And if there can be a delay of numerous hours between the time of the injury and the time of the symptoms, then it is also possible that several people could have been involved in caring for the child during that time. Therefore, there are other people who should be investigated, not just the individual who was with the child at the time the symptoms first appeared, in order to determine how and when the child sustained such life-threatening physical trauma. A shaken baby case is extremely difficult to prepare and present to the jury. The cost for the necessary experts is staggering because most of the evidence relies upon highly specialized medical expert testimony and medical research papers. The most serious problems, however, are 1, insufficient research, and 2, the inaccessibility of supporting research. For one, simply cannot shake a baby in a lab with monitors on the baby to see what damage is done on the brain and body. Secondly, supporting studies are not only difficult to find, but sometimes are written in other languages. These two factors enable the child advocacy expert to substitute their judgment and their own personal or political beliefs for facts. Even the educated public is not familiar with head trauma studies or the complexities of shaken baby syndrome. Therefore, the role of the defense team is to teach the jury the difference between scientific research and the opinions of an advocate. Finally, the defense must educate the jury members on the actual state of knowledge with regard to brain trauma so that they can determine the truth of the cause of the child's injuries and who is innocent and who is guilty. Thank you. We get numerous telephone calls wanting to know whether or not we recommend taking a police polygraph when the police call and offer you one. We believe that police polygraph examinations are not reliable. We don't need to get into the scientific discussion as to the reliability when an example will suffice. We have had clients that have taken 2 polygraph examinations. Our examiner is the individual who trained police officers throughout his career at the California Department of Justice and later retired. He now does private polygraph examinations. We have had cases where our examiner has passed the person and found them to be not deceptive, while the police department examiner, who is trained by our examiner, found them to be deceptive. Why? We have also seen certain police examiners that never find that anyone passes a polygraph. They always find that the suspect is deceptive. Further, many prosecutors are not moved by a favorable result on a polygraph machine. They only believe the results if they point towards guilty. Why? Well, they have explained it to us that psychopaths have no conscience and therefore demonstrate no stress when they're lying. They believe that a pedophile is a psychopath who can pass a polygraph. If the suspect flunks, they believe the result. If the suspect passes, they don't believe the result. However, nothing is absolute, and on a few occasions we have had cases dismissed upon polygraph examinations. With some lawyers, if the client takes a polygraph and fails it, there is a tendency to stop preparing the case because of the belief that the client is guilty and the case should be plea bargained. At the very least, the attorney does not have the zeal that he or she might otherwise have had. Further, the client may become afraid that the attorney doesn't believe in the case and will not try as hard. There is a breakdown of trust in the attorney-client relationship. With police examinations, too often the polygraph examination becomes a ploy used as part of the interrogation process. This is how they are trained. It is the questioning of the client before, during, and particularly after the polygraph examination that they want. Even if the person passes or it's inconclusive, the officers are allowed to lie. They can tell the suspect that they failed the polygraph examination and then ask the suspect what could have happened that would have caused that. Maybe you accidentally touched her, something to that effect. The polygraph examination is literally used as a psychological ploy to apply pressure to extract some sort of an admission. We would recommend that you not take a police polygraph examination. If you want to have a polygraph examination, you should go to a private, reputable polygraph expert. I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses, are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case.